Well, hello and welcome to the November 2022 edition of Outline, DLA Piper's regular planning law update series. My name is Trevor Ivory. I'm the head of the UK planning team here at DLA Piper. I'm joined today by two of my colleagues, one of my partners, Sophie Stewart, also the planning team, and legal director, Michael Greig, who is a member of the planning team and also one of our experts on Scottish planning law, so brings a Scottish perspective to today's discussion. So morning, Sophie and Michael, thank you for joining me. And today's session is a change from what was originally advertised. We were going to be talking about planning enforcement, but we're now going to do that in December because no sooner had we said that was what we were going to do, the Supreme Court finally handed down judgment in what I think it's fair to say is probably the biggest planning case of 2022, which is the Hillside litigation. Now, those of you who have been following Outline from the very beginning will have heard of Hillside before. Our very first Outline back in December 2020 looked at the Court of Appeal judgment in the Hillside case. So I'm going to give a brief introduction to the facts of Hillside now, but I'm not going to go into a huge amount of detail because if you are interested, you can always go back on YouTube and have a look at the December 2020 episode for more details on the facts. But I think for the purposes of today's session, in order to set the scene, that the case is very much concerned with the question of the implications of implementing multiple planning permissions across the same site or part of the same site. And in the Hillside case, we were talking about a site in Snowdonia National Park, which had originally been granted a planning permission back in 1967, so a very old planning permission for 401 dwellings. It was a residential consent. Probably not something you'd get permission for in the national park here in 2022, but it was, I'm not even sure whether it was a national park in 1967, but certainly planning permission granted, and that was a full planning permission back in 1967. Even by development standards in the UK, I think it's fair to say the development of that particular site has been slow, in that, as at the time of the Supreme Court case, only 41 dwellings had actually been built out. And actually, interestingly, not one of those 41 dwellings had been built pursuant to that original 1967 planning permission. They'd all been built in accordance with a series of discrete standalone planning applications that had been made subsequently and across a number of years, all the way up to 2011. Those dwellings that had been built were not in accordance with the master plan that had been approved as part of the 1967 permission. That's quite a critical point. So there was an inconsistency between what had been built and the wider planning permission's master plan. Nonetheless, that all appeared to be fine. Planning Authority had been aware of all of this going on throughout the period. But then in 2017, there was seemingly a bit of a change of heart at the Planning Authority. And in 2017, Snowdonia National Park Authority wrote to the developer and asserted that in their view, the 1967 planning permission was no longer able to be implemented and was no longer capable of sustaining any further development because of the inconsistency between the master plan approved pursuant to it and those subsequent planning permissions that had resulted in the 41 dwellings being built. Hillside, as owners and developers of the site, weren't overly happy about that, and they made an application to the court for a declaration that the council was wrong, and that the 1967 planning permission was still extant and still capable of being built out, at least as far as it hadn't already development hadn't already happened pursuant to the other permissions. In the Court of Appeal, the court said no. And agreed with the Planning Authority that the 1967 planning permission had expired. That then came to the Supreme Court back in July this year, and as I say, a few weeks ago, it's fairly hot off the press, we have the Supreme Court's judgment. And the Supreme Court agreed with the Court of Appeal and has held that 1967 planning permission has expired. So that's the issue we're going to look at today, is what are the consequences of that for developers and landowners moving forward. And I think to begin that discussion, we have to go back to an earlier case, because what the Supreme Court were considering in Hillside was very much the 1973 case of Pilkington and the Pilkington principle as it's become known. So just sort of very briefly before I bring my colleagues into the discussion, in terms of the Pilkington case, it's worth just looking at the facts of that case as well. That was a much smaller site. Planning permission was granted for a bungalow, a single bungalow on a plot. That bungalow was built out. Once the bungalow was constructed, the landowners then discovered that there'd actually been an earlier planning permission granted for another bungalow on a different part of the same plot. So critically the same plot, but with the bungalow that was consented there being built on a different part of it. And so what the landowner wanted to do was to build out both bungalows and get two for the price of one, effectively. What was critical to the case there was that the description of development for that older planning permission was not just for the bungalow. The description of development, and indeed the approved plans, identified the bungalow and then the remainder of the plot being in use as a small holding. So it was covering planning permission for the construction of the bungalow, but also then for the use of the remainder of the plot as a small holding. And that was critical because what the court had held in the Pilkington case was that it was impossible to implement that older planning permission because it couldn't be built out in full, insofar as it wasn't possible to use the remainder of the plot as the small holding because another bungalow had already been built on part of that small holding. So because of that incompatibility between the two planning permissions, the court had held in Pilkington that the older permission was no longer capable of being developed, and it had expired to all intents and purposes. And they set out a test there, which the Supreme Court in Hillside have now adopted and have approved, and that the Supreme Court effectively describe it as the physical impossibility test. So if it has become physically impossible for a development or for a planning permission to be built out in its entirety, then that planning permission is no longer capable of implementation and no longer capable of sustaining further development. So those, in a nutshell, quick facts of the Hillside case and then quick facts of the Pilkington case that it's all based on. But Sophie, I'd like to bring you in, perhaps, if I can, at this point. I think the Supreme Court talks about the physical impossibility test. One of the things that I think the court seems to me was keen to stress was that there's a difference between impossibility and incompatibility. And I think they were looking at the question of whether incompatibility would of itself be enough to prevent those planning permissions coming forward. What did they say about that?
Oh, that's right, Trevor, and good morning, everybody. The court was very keen to stress the incompatibility, and I think the most likely circumstance where that will arise is where there are conditions attached to the original permission A, which if permission B, or indeed attached to permission B, if permission A is built out, there could be a potential breach of. So whilst the physical development is capable under both, those conditions would clash heads. And they were very clear and at pains to say that would not be sufficient to engage the principle, therefore that the benefit of the partially developed permission would be lost. The Supreme Court used, I think, a very good example, a 1992 case of Prestige Homes, which was reaffirmed in the Court of Appeal 10 years later in 2002 in Staffordshire and NGR. And in that case, you had a permission for a dwelling house, again, that had a condition attached that required retention of trees on another part of the site where the house was going to be built. A second planning permission came along for another dwelling on the part of the site where the retained or the protected trees were. Obviously, there was a requirement to cut those trees down in order to build the second dwelling. And in that case, it was held that whilst there was clearly a breach of condition, both developments could go hand in hand, because unlike Pilkington, where there was a clear requirement to use the rest of the plot as a specific use, a change of use to a small holding, in this case, it was garden curtilage. There was no change. It was just this condition concerning retention of trees, and the Supreme Court said that wouldn't engage. I think what they they didn't refer to as Pilkington Light, but it is a slightly more reined in, I think, version of Pilkington, because they were, as I say, at pains to stress that incompatibility is not sufficient to engage. It was interesting as well, the Supreme Court stated that the inconsistency between the schemes has to be material as well. So the fact that there's a minor physical incompatibility or physical impossibility of itself would not be sufficient to engage Pilkington, Mark, Hillside, if in the context of the scheme as a whole, that impossibility wouldn't have a material effect.
We were having a discussion before we started the session, weren't we, about what that meant? And I think, Michael, you made the point that if sticking with the residential example, if you'd got a new planning permission for different house types, perhaps we were sort of debating whether does that mean then, yes, there is a bit of impossibility, you can't build the house types that were originally approved, but actually is that material? And I think we were all sort of probably all of a view that to an extent that there's not necessarily a right and wrong answer to that. It's going to be an element of planning judgment, but that feels like the sort of example of where there is an incompatibility, and that is effectively an impossibility, but it's one that just probably isn't sufficiently material to engage this Pilkington principle and have that result. I think that.
Yeah, and I think there's some interesting questions that arise as well. So kind of, as per our pre-discussion, looking at substituting house types, or flipping two plots. So where a 3-bed next door to a 4-bed, vice versa, put them the other way around. But then there are kind of the more complex issues. So what if you keep all of your highway alignments and everything else the same? You don't even substitute a house type. You just shift the orientation or the alignment to the highway slightly on a plot. So again, there's a physical overlap, but there's no real change. But what if that change, that slight physical adjustment, actually then causes overlooking issues into neighbours' gardens? So the physical incompatibility is very, very small, but actually the consequences in a planning sense are much larger. And much more material. And again, I think whilst the Supreme Court's clarifications are helpful and does allow a very small amount of flexibility, albeit there's probably a lot more litigation to go on it, there are still a lot of considerations that are going to have to be had on a case-by-case basis.
Yeah, but I think the sort of important point from all of that is mere incompatibility isn't enough. Yeah. It's got to be physically impossible to build out the development that was approved, and that impossibility has to be material. So this isn't this isn't going to apply, I would suggest, in many cases. It's going to be quite specific cases, although the consequences are clearly severe and we need to be alive to them. But that is helpful, it seems to me, in narrowing the potential scope of Pilkington. Now, one of the approaches or one of the arguments that the developer relied on in the Supreme Court, and indeed in the lower courts, was the argument that actually what had been granted in 1967 was a series of discrete developments, multi-unit development, I think is how the Supreme Court put it. So sort of saying, well, look, it was always envisaged that each parcel was going to come forward, or each phase perhaps was going to come forward separately, and the fact that you've twiddled with one with a new permission shouldn't prevent the others. And that there was some logic to that argument, in that they were relying on another case, the Lucas case, which had taken exactly that approach. Mr. Justice Wynne in that case, hadn't he, Michael? But the Supreme Court, I don't think, liked that approach, did they, Michael?
No, I think that's probably right. I mean, essentially, your developer in Hillside made the argument that where you've got a planning permission which gives you authorization for a number of buildings, then the proper interpretation of such a permission is that it permits the construction of any subset of those buildings, and that there's no reason why a landowner couldn't combine development authorized under that original permission with development authorized by other permissions. So the point that we're making was I suppose quite a general point in terms of how you interpret what you might call a multi-use permission. And you're right, obviously what they did there was they relied on the Lucas case. And again, it's probably worth just thinking about the facts there, because in that case, the planning permission, again, this is quite an elderly permission as well, but come back to the 1960s again. So that was planning permission for a cul-de-sac. So you had a row of semi-detached houses on either side of the road. You then had a second planning permission granted for development on one of the sides of the road, and that was for a smaller number of detached houses. And what the developer did was to construct two houses under the second permission, so the detached houses, and that meant it was then physically impossible to build the other houses in terms of the original permission. So Justice Wynne accepted the developer's argument that permission could properly be regarded as effectively separate permissions to erect each of the individual houses shown on the plans of the original consent. So they were able to build the remaining original houses in terms of the original consent, even though it was physically impossible to build the whole development. So not surprisingly, developer in Hillside went along with that argument and argued the same should apply to their development. But the Supreme Court wasn't impressed by that argument and came to the conclusion that Lucas had actually been incorrectly decided. And it's worth having a look at their reasoning on that, because when dealing with a multi-unit development, and this is kind of picking up, I suppose, on what some of the points that Sophie was making earlier on about the potential implications of how a change in the layout of development can impact on immunity and things like that. So they said that when a planning authority is looking at a multi-unit development, they'll have to look at a range of factors, and they might be things like the total number of dwellings, the overall layout and physical appearance, but it can also include what level of infrastructure is required, issues of sustainability. Essentially, I suppose what they're saying is that when you're looking at a multi-unit development, there are wider implications of that development beyond just the individual elements to it. So what they said was that when you're granting permission for that kind of multi-unit development, the planning authority can't be taken to have authorised the developer to construct individual parts of it in a way that's inconsistent with the approved scheme, unless there's some clear contrary indication, and we'll probably come back to that later. So that's the fundamental point that the court made there on that point, and essentially, whereas we had the developers making this general point that it was possible to implement and effectively chop and change between permissions. The court saying, well, no, that can't be done unless we've got express provision in the planning permission to that effect. And indeed, they were saying that Hillside was a paradigm instance of an integrated scheme which could not be severed into component parts. So it's at the extreme end of the spectrum, if you like.
I think it's really interesting what they have to say about Lucas, and there's a bit of reassurance compared to the Court of Appeal judgment, I think, at this point, because in the Court of Appeal, Lord Justice Singh left open the question of what happens to development that's already been carried out pursuant to the permission that is now no longer capable of supporting more development. And I think that sort of comes through because that was part of Mr. Justice Wynne's logic in the Lucas case that the Supreme Court said was wrong, was saying, well, hold on, if the consequence is it falls away, then what about the houses that have already been built pursuant to that planning permission? Do they become unlawful? And I think the reassuring point for me is the Supreme Court said no, development that has already been built out pursuant to that planning permission is lawful. The question is whether that permission can continue to sustain further development after implementation of the inconsistent, incompatible planning permission. So I think that's a relief, it seems to me, in that we don't have to worry about whether, if this happens, everything you've already built has become unlawful. That's gone away. That's been clarified by the Supreme Court, thankfully. So I think we now understand the issue. I want to come on to the practical point about, well, then what do we do about this, and what are the solutions? But just before we do, Michael, I'm going to come to you because we've had a question, and the question is, how relevant is this case to Scotland? Bearing in mind, obviously, planning is a devolved matter, and you have long before devolution had a different planning system in Scotland. So what's the relevance to Scotland, if any?
Yeah, it's a good question. I mean, yes, planning permission had long been devolved in an administrative sense, and obviously the systems are diverging in terms of their how they operate. But in terms of the fundamentals as to what is planning permission, what are the issues associated with the implementation of planning permission, north and south of the border, the basic principles remain the same. My view would be that this is a case where the issue of Hillside is directly applicable in a Scottish context, and whereas previously we had a Court of Appeal decision, which is clearly relevant in Scotland but not binding. Now we've got a Supreme Court decision which elevates this to another stage, and I think this would now be regarded as good law in a Scottish context as well.
So we're all in it together on this one.
I mean, it's an interesting point.
Not necessarily better together, though.
It's an interesting point, though, because of course, in situations like these, we're normally talking about this. Of course, is England, because planning's devolved in Wales as well. But this is a Welsh case.
Yes. Yeah. Well, that's a good point. Yeah.
Yeah. So we really are all in it together. Right. Okay, well, we're all in it together. So let's now try and get out of it together. What are our solutions? And I think there are a few, aren't there? And I want to start by looking at the solutions where the problem already exists. So where you've already got your original planning permission, because I think that the two are slightly different. So if we assume we already have a planning permission, we're now looking to do something different on a part of the site that planning permission covers. I suppose the most obvious first answer, and the Supreme Court sort of suggested it was a perfectly sensible answer to them, is you could just apply for a whole new planning permission, couldn't you, Sophie?
Yes. Yes, you could. Indeed, Trevor, and you're right. The judgment of the Supreme Court references applying for a whole new permission using the same red line boundary at a number of different points through the judgment, and actually as a solution for a number of different questions. So essentially what you would do is draw exactly the same red line boundary. You would show what has already been built out on the plan. You would show the balance of development under the original permission still to be built, and then your new area of proposed amended development. And essentially the situation you end up in, assuming that is granted, is that you then have two planning permissions for exactly the same site, and you are free to choose as a developer which one you then build out. And that's not really changing from the principle that has been long held and established, that if you do have multiple planning permissions, you can pick and choose which one you like. And as you alluded to just a few minutes ago, Trevor, what has already been built under original permission A, it's been clarified and is absolutely certain now that that remains lawful development at the point that you start to develop under permission B, which seems on the face of it, I guess, quite a nice, neat solution. But there are clearly lots and lots of practical issues that might make it less attractive, I would suggest, in the real world. Not least cost of a new application, the time it will take to get that new determination, implications about changed planning policy, the need potentially to involve other parties or to serve various notices if the red line site has been parcelled off and is in separate ownerships, potentially a biggie, and one that the Supreme Court did start to grapple with, but the need for EIA and ES. Would the application for a whole new planning permission require a whole new environmental impact assessment carrying out, or could existing documents be updated? And as is probably always the case with planning, it will largely fall down to, I guess, a question of fact and degree for each site.
As you were speaking, a question came in, although I think you answered it, which was, would that new application be free? And of course, the answer is that no. That would be part of the cost, wouldn't it? And but particularly, I sort of think residential is another. We keep coming back to the Resi example, but it does apply elsewhere. But I think it's probably the example that's clearest. But a whole new 106 new planning application with a new 106, you might, if you've already got dwellings being occupied and things, you've got all those challenges of trying to get the various parties within the red line to sign the 106 potentially, unless you can persuade the authority to carve out the owners of the plots. But all of those sorts of things, I mean, it's not necessarily quite the easy, attractive option as the Supreme Court sort of thought it was. I think the planning policy change is an interesting one. If you've got a new plan with some more significant financial contributions under the 106 or more stringent affordable housing requirements or whatever it is, then you might not be terribly keen on having that battle as to whether you've got to provide those increased contributions across the entire site in order to make a change to a discrete part of the site. All of those things potentially mean it's not quite right.
Yeah.
So,
I was going to say,
sorry.
I was going to say there's the interesting point, I guess, as well, and it's one that actually worked to the developer's advantage in Hitchens, which is sort of the hook the Supreme Court started with to look at whether a balance remains lawful or not. But that's if you've got a 106 under the original permission that's contributions or the like were in phases and some have already been paid, will the LPA take those into account and deduplicate in any new section 106, or are you paying twice?
Yeah. And a lot of these things, the answer is if you were prepared to appeal, you'd probably get common sense on a lot of that. But if that's just adding yet more cost into a process that seems wholly unnecessary, you might not get quite the same commercial approach from a planning authority. Some planning authorities would take an approach of wanting their pound of flesh, regardless of SIL tests and everything else. So there are some challenges. But it is an option. So new planning permission is first option. Michael, a section 73 of your existing permission feels like another alternative that might be worth considering, or of course the equivalent of section 73 in Scotland, which you're now no doubt about to tell me what that is.
That'll be 42.
There it is, 42.
Scotland, so there we go. So yeah, so this is the mechanism whereby you can apply to develop without complying with some of the conditions on the original consent. It's often called a variation of conditions. Well, technically speaking, it results in the generation of a new planning permission with its own set of conditions, and you've got two consents there. Or you might do if it wasn't for Hillside, which got rid of your existing one. But yes, that's a mechanism. So the circumstances in which section 73 or section 42 will be helpful, I suppose, will very much depend on the facts of the case. Because obviously, if you're going to vary a condition, you've got to be able to identify a condition which you can vary, which gets you the result that you want and gets you to that revised form of development. Now, quite a number of permissions tend to have a condition on them, which require you to comply with the approved plans, which are then listed. So one obvious way of changing the level of the type of development would be a section 73 or section 42 application to vary that condition and effectively substitute new plans. Obviously, the difficulty is if you don't have a condition like that, then that's not really an option that's open to you. So section 73 won't necessarily be an option in all circumstances. The other option, I suppose, that occurred to me in terms of varying conditions is picking up on the idea that from the Supreme Court that you could have a clear expression in the original planning permission that severability is permitted, whether you could retrospectively introduce that formation of it into a planning permission. I suspect that might be quite tricky, but I suppose, again, we'll talk a bit more about this later, but I suppose you might have a scenario where you have a development that is clearly contemplated to be phased and subject to individually severable elements, but the permission perhaps doesn't entirely make it clear that that's the case. So I guess there might be circumstances in which that could potentially be a way of doing things. If you've got a consent that you know is going to be around in the long term, and you want to ensure that you preserve it and you don't accidentally get rid of it through incompatible planning permissions, maybe that's the way you're dealing with it. I think, though, what we do need to bear in mind is that Section 73 applications do have their limitations. Particularly, we had the Finney case from a couple of years ago, so you can't use that type of application if what you propose to do would result in a revised type of development compared to the original consent. So that it's limiting. Again, it very much depends on what's the nature of development as described in the original consent, and whether you're actually able to vary it in such a way within the four corners of that original consent. And the other thing, I suppose, is just, again, going back to the concept of what a Section 73 application actually is, that it results in a fresh grant of planning permission. So again, in picking up what Sophie says, that can potentially still lead to issues in terms of potentially changed policy requirements since the original consent was granted. You might also need a fresh Section 106 or Section 75 agreement, and that again brings into potential issues with with the need for other parties to be involved. So it is an option, but very much time dependent, I think.
I think that it's quite a neat option where you have the condition with the plans, and all you're looking to do is to change the layout, isn't it? That feels like that's where Section 73 is efficient, where you've actually got changes of use to certain things. And I think that feels like a real challenge is the Finney point about you can't use Section 73 to change the description of development, because one of the areas where this I think will come up is if you've got a long-term planning permission that's being built out over a number of years. So whether that's a business park or a town centre regen scheme or whatever, uses will go through economic cycles and uses will change, and where you get into difficulties is those uses aren't necessarily achievable just by flipping a plan under a Section 73. You need to revisit the description of development, particularly if you've gone for a very detailed description of development. And one of my little hobby horses, as an aside, is I'm always encouraging people who are drafting descriptions of development to put less is more. It always seems to me, because of too much detail just unnecessarily restricts your ability to be flexible moving forward. And that Finney case, I think, is a real challenge there in terms of not being able to use Section 73, where you're looking at doing something that results in a change to the description of development. One question that's come in while you're speaking, Michael, was whether you can Section 73 a reserved matters approval. I think the answer to that, I can't remember the case, but we talked about it fairly recently, I think, but there is a recent case that confirms that is, yes, you can. You can change the conditions, whether the conditions on a reserved matter or a full or outline consent doesn't matter. So it's Section 73, as long as what you're doing is changing the conditions in some way, then Section 73 is always an option, I think. The other route, which I think has gained quite a lot of traction, certainly we've advised a number of clients to use it since the Court of Appeal judgment, is to look at 96A or its Scottish equivalent to make non-material amendments. And of course, we're dealing here with things that are material. So the 96A usually can't make the change that you're wanting to make, although sometimes it may be the option. But if what you're looking to do is material, and therefore engaging this whole Pilkington issue and Hillside issue, you can, what I've seen done is obtain the new planning permission for the incompatible development. But once you've got that, prior to implementing that planning permission, to revisit the original permission using 96A in order to amend that original permission so that it can take account of that new otherwise incompatible development that you've got pursuant to that second planning permission. And I've seen that done either by amending the red line or done by effectively just removing from the scope of the original permission any development within that area of overlap, so that there is no physical impossibility issue engaged. And that feels like it's going to continue to be quite a well-used route, because it is quite neat. I've had some discussions with certain planning authorities where they said, well, actually, is what you're doing material? I think if you've already got planning permission for the alternative, I think it isn't material. It might have been if you tried to do the change via 96A in the first place. But it seems to me that if you've already got planning permission, and it was clear that the local authority was intending that those two planning permissions would knit together, then almost by definition, it's not a material change at that point to address this legal issue, to allow those permissions to overlap. So I think 96A, or as I say, its Scottish equivalent, Michael, Scottish equivalent. There we are. See, we're rolling them all out today.
Let's all go.
So you using that, I think, will remain quite an efficient tool. It puts an extra step in the process, but it protects against this issue and allows you to know very clearly that you can continue to bring forward development under both permissions without causing a problem. I think the question of variation, so Sophie, if I can perhaps come to you, the developer in Hillside, they relied quite heavily in the Supreme Court, particularly in their oral submissions from the look of it, on the argument that the permissions that had been granted subsequently were variation permissions that were intended to vary. So of course you can't vary an original planning permission as much as everybody routinely thinks we do. You can't vary an original that permission other than by 96A, but they were saying that it was tantamount to it, and therefore those permissions should be allowed to all sit comfortably together. The court didn't like that argument on the facts of the particular planning permissions, but it didn't rule it out as entirely either, did it?
It didn't, but I think the circumstances are so limited, and the reasoning the court gave so strict that the reality is it has closed the door. So this is one of the examples where they talked about the use of a new whole site application. So essentially drawing the red line around the original permission and then calling the new permission a variation of the old. Yes, then I suppose arguably at law it would be a variation, but the reality is you've still got two different planning permissions. It's just one then refers to the other. The court very much took the view that variation of planning permissions is a matter of statute, and that we have 96A and that we have 73 and the equivalents in Scotland. And outside of that, there is no discretionary scope for planning authorities to vary a planning permission, essentially. So they didn't close the door on the idea, but in practice, there's no point referring to it because you just end up with a new application with the same red line.
Yeah, because they said unlikely, didn't they? It was unlikely that was what was intended. But I think the one little glimmer of light which I latched onto was that the point that the court had made was that for whatever reason, the developer hadn't put into evidence the plans sitting behind any of the later planning permissions. And at one point in the judgment, they sort of say, well, if there were a plan that showed how this new development was going to knit into the wider master plan, then maybe. And it felt like that was the sort of the one that they, because it wasn't in front of them, they didn't know whether there was such a plan in the case that they were looking at. But it felt as if one of the approved plans on the new permission showed how the master plan for the wider site was going to interact with that new standalone permission, then they weren't quite ruling that out. So I think, as you say, there's a risk to it because the court didn't say it was good. They said, not sure about this, but it's not in front of us, therefore we can't really think about it. But that feels as if that is something that just needs to be kept at the back of people's minds, as it might be in some circumstances your only option, and it may be at that point one to think about perhaps.
I suppose I wonder what that ties in with the kind of materiality point. So that, that's the purpose of showing that sort of plan, that you're demonstrating that everything does fit together, and hence there's not a material impact on your ability to implement the rest of the existing development.
Yeah.
I guess we don't necessarily know until this.
No, it raises the interesting point about we talk about drop-in applications, but on the facts of Hillside, none of the 15 subsequent permissions were in fact what we as practitioners would probably consider to be a drop-in application. They were all standalone that essentially redrew just the underlying estate infrastructure from earlier permissions. So I think you're absolutely right, Michael. A true drop-in, something that almost can slot in like a jigsaw piece onto what you've already got on your larger site. The question then of materiality and departure from the original scheme, I think, becomes the primary question as to whether Hillside will be engaged or not.
Okay, so there are some solutions, some with challenges, and it feels as if with different solutions in different scenarios, won't it? But there are some solutions, as long as people are thinking about it and getting the right advice at the right time, critically making sure they've got it right before they implement that second permission. In all circumstances, don't implement that second permission until you've had that advice that you're in the right place to do it without losing everything that you've got before it. But what about stepping sort of back in time? You've got your first permission. Are there ways that we can resolve the situation there? Because it seems to me, and certainly I'm grappling with a number of these at the moment, where clients are looking at large schemes which they know are going to come forward over a number of years. Sometimes they don't even own the whole site at the point that they're applying for planning, and that's not unusual if you're doing town centre regen, particularly if you think you're going to need CPO. You've got to get your permission before you can go for your CPO powers in most cases. So is it possible to kind of think about it at that stage and create a planning permission that actually is sufficiently severable, maybe, that it will withstand incompatible development coming forward on discrete parts over the life of that permission? Michael, I don't think the court entirely rejected that as an idea either, did it?
I think they certainly recognise it. I mean, I've already kind of referred to a few places already where they speak about the generally speaking, with a multi-unit permission, you can't do that, but unless the planning permission says otherwise. So they're obviously contemplating there is the possibility of having a planning permission that makes it clear that the various elements are severable. And indeed, what they said is that where you've got a multi-unit development, it's a question of interpretation, whether the permission authorises a number of independent acts of development which can be constructed separately, or whether it's to be construed as a permission for a single scheme that you can't disaggregate like that. So they are saying you can do it, that it's a question of interpretation. What they don't do, unfortunately, is provide you any guidance as to how you might approach the question as to which of those two types of permission you've actually got. So I suppose you've got to think about how would you actually do that. I suppose one of the first issues, I guess, is going to have to be you're going to have to convince the planning authority that it is that form of development. So the application documents and the plans are going to have to clearly define the various development areas and make it clear that the intention is that each of these development areas will be capable of being implemented separately and potentially subject to further planning consents. And then you've got to think about how might the permission itself be framed. And again, obviously that's at the end of the day for the planning authority to determine. So I guess what you would hope is that between the developer and the planning authority, they would work together to come to a form of permission that achieves that aim. So I guess the conditions would have to make it clear that the various elements are severable. I guess what you might need to have would be separate conditions, perhaps, for each of the set subzones and phasing conditions and that sort of thing. I suppose where where these things might become tricky, I suspect, is if you've got other conditions that the planning authority want to impose in relation to phasing. So, for example, if they want to ensure that you can't build more than a certain amount of housing before a certain amount of employment land comes forward, and then you start trying to change those, I guess that's where it potentially maybe becomes unstuck. But I guess I suppose my thinking was going back to the kind of the tests that the Supreme Court set out as to why it is that multi-use developments cause a difficulty in terms of severability. I suppose maybe that's what we have to apply our minds to. So looking at they were looking at things like the total number of buildings, the overall layout, how you treat infrastructure, overall sustainability, those sorts of things. I suppose the application's got to be thinking about those sorts of issues and demonstrating why the planning authority should be comfortable to be able to grant a consent which is capable of having severable elements, notwithstanding that they have to apply their minds to those sorts of questions.
It's got to be a collaborative effort, isn't it? You said that. I think the planning authority would need to be intending to do it, and you'd need to work with them to show that that's their intention. And I think the conditions, I entirely agree. Some informatives maybe to actually say in terms of this is what we know what we're doing and we're intending to do it. I think it would take. I think it's possible, but we would need to be working very closely with the planning authority to frame that planning permission in as clear a way as possible to minimise the risk of someone saying, well, actually, no, you've not done enough. It's not sufficiently clear, given that the court sort of has made it quite clear they think it's unlikely that that's how a planning permission should be interpreted. So somebody's made the point in question. We've had lots of questions. I'm going to try and come onto those now and try and get through as many as we can. We're not going to get through them all because we've had loads, but somebody said, yeah, this is just making the system even more complicated. Is there any proposal for legislative reform? And obviously we've got the Levelling Up and Regeneration Bill going through Parliament at the moment. We think, as at the time we're recording this, we're on our fourth Secretary of State, I think, for the Levelling Up and Regeneration Bill, although conveniently the fourth one is the same one as the first one. So we're back to where we started, but assuming that bill is going to move forward, there is the opportunity for change. There's nothing in it at the moment that does, but I think this, for me, this is yet another example of why we really ought to have a statutory power to vary planning permissions, because it seems to me a lot of this, 96A, Section 73, the Finney case, now Hillside and Pilkington, these are all, I think, examples of why there's a case for actually Parliament being able to resolve all of this and deal with all of those problems by simply giving us a statutory power to amend a planning permission in a case where there is a material change being made. And I think that feels to me would be the very simple solution that would also kill a number of other birds with the same stone, so to speak, in that you deal with the Finney description of development limitations on Section 73 and the materiality point around 96A. So that would be my answer to that question is no, there isn't a legislative proposal, but that power would seem to me to quite neatly deal with it. I don't know whether either of you have other thoughts on legislative reform there.
There's a very small reference in the explanatory text in the LERB, but it doesn't make its way into the bill. So I think it's been thought about. It's probably up till now been put in the too difficult pile. I think Hillside crystallises this, and whilst it probably still remains quite difficult, it needs to be grappled with.
Yeah, I agree with that. I think that from a Scottish context, obviously the difficulty is that bill isn't going to apply up here. We've just had an act, and to be honest, I'm just not. I think today I don't think Hillside has really in Scotland had the profile that it's had elsewhere. So I'm not sure at the moment that the Scottish government are as switched on to this point as maybe they should be. But it certainly seems to my mind that there are a lot of that this is making life more difficult than it needs to be. That you're having to invent solutions to a problem which, frankly, why should we have anyway? Why can't you have a simpler mechanism just to allow you to amend the permission? Obviously, if the planning authority thinks that what you're proposing isn't appropriate because it doesn't fit in with the rest of it, well, they can always refuse it. But why do we need to make things so difficult? Suppose.
Yeah, the planning system making life difficult. I mean, who knew? Who knew indeed? Right, we've had quite a few questions actually, asking about the relevance of the case and the Pilkington principle to minerals planning, which of course is a sort of slightly peculiar subset of planning in that by definition you've got usually very big sites being developed over decades, actually, rather than years, and actually quite often you will get planning permissions over the course of that slot in, whether it's building new plant or extensions or whatever to it. So the questions, I think all of the questions trying to draw them all together is this a problem for minerals planning as well? I think the simple answer is yes, isn't it? I don't see there's a distinction. If you are getting a planning permission for part of a site that has the benefit of a minerals consent, and that planning permission, once built out, makes it physically impossible for that original minerals consent to be developed out and built or excavated out in its entirety, I think the principle is the same.
I think minerals ones actually, thinking about it's probably the ones where it's where the obvious areas where it will be an issue that needs to be looked at, because you often have lots of different permissions that apply in your expansion areas, and then and sometimes the question as well is the original consent, because often you have an original consent that's from a very, very long time ago. So you are looking at whether that original consent is still valid or not. So I think you are going to have to look at this on a case by case basis, and figure out whether what permissions are actually still live.
Yeah, and I think that's absolutely right, Michael. I think there's also this is going to potentially have to be considered on renewals, on ROMPs as well. And I think it minerals for me is probably going to be the area where materiality of change is at the forefront. So I'm actually dealing with this issue at the moment, where we are life of a quarry is coming to an end, and we're looking to change some of the decommissioning and remediation requirements, which have started on part of the site that's been fully excavated and are yet to come forward on parts which are still going forward. And the argument we've been having with the Minerals Authority and that has been accepted is that the purpose of the original planning permission is extraction, and actually what we're doing on the surface doesn't in any way depart from the original intention of being able to extract. Therefore, anything we're doing sort of around other edges of the site, away from the working face of the quarry, doesn't change or doesn't materially depart to what has been authorised under the original consent. And we've made that very clear. Trevor, you mentioned informatives before. It is on the face of the decision notice that it has been considered. It is not considered to be an issue.
But one of the specific questions that came through on minerals was an example. Feels like it might be quite a live example for at least one person in the audience today, of a minerals site where you get a planning permission to use part of it as a solar farm that you're intending perhaps to be there for 50 years, after which you're intending to continue to extract the mineral from underneath it. I think if it seems to me that if it's a temporary permission, then we always know with a temporary permission you can go back at the end of it to the previous use. Although the question doesn't say it's temporary permission, the question just sort of suggests that there's an intention after 50 years probably to go back. It feels to me as if there is a bit of a difference there, because if you're getting a planning permission, a permanent planning permission for a solar farm, that you're not intending then to, even if you as the applicant are intending you might at some point go back to it. I think the implementation of that permission, it seems to me you are losing your mineral extraction consent, I think, at that point.
It's an interesting one, though, isn't it? Because they're obviously dealing with different parts of the ground. Does constructing a solar farm on the surface necessarily. I mean, obviously, but whilst it's there, you can't extract. But if, as you say, if it's temporary, you know.
Yeah, and I suppose that's the point. Even if it was a permanent consent for the solar farm, you'd effectively have to demolish the solar farm to excavate under it, unless you left such a sufficient amount at the top that you could go in horizontally.
I'm assuming this is surface extraction rather than sort of deep mine. Obviously, if it was deep mine, the two can stick back comfortably, but
you'd have to demolish the solar farm anyway. So if you then had a partially implemented planning permission that then there was no physical impossibility, you know, I mean, I suppose it comes back to the question in Pilkington: if they knocked down the bungalow built pursuant to the second permission, would there be anything? Admittedly, by then the first permission probably would have been out of time, but would there be anything to stop them implementing the first permission at that point if you bulldoze the second bungalow?
I suppose the question is, does that planning permission? I think the challenge for that for me is that that planning permission for the second bungalow expires at the point that it's no longer capable of implementation. You'd almost be bringing it back, wouldn't you? Trying to resurrect it post, but it's an interesting point. But so I think in terms of minerals, I'm conscious of time, so we always try to finish within the hour, and we're coming up to it. We could go on all day, couldn't we? In terms of minerals, yes, it's a live issue that needs to be being thought about as well. We are coming to time. There are other questions. Apologies, we haven't got to them all. I'm just going to pick up on one more because it feels particularly relevant. Was the question of if you've got inconsistent reserve matters approvals, does Hillside become engaged? It seems to me no, because but I'll throw that out to the panel. My thinking is no, because there's no incompatibility between two different planning permissions. If your reserve matters overlap and are different, then you don't lose the planning permission because both reserve matters are under the same planning permission. So I think the answer to that is no. You can be more relaxed if you've got incompatible reserve matters. Agreed?
Yeah.
Good. Sorry, Michael, were you going to add something then?
No, I just said yes. I think I said yay, actually.
Very chilled as we come up to the hour.
Indeed.
Great. Well, look, we are at the hour, so I am going to leave it there, but in 30 seconds each, if you want to, are there any other practical consequences that we ought to be mindful of? Michael, come to you first in 30 seconds.
Oh, gosh, right. Commercial property transactions where you sell land with a big planning permission on it. I think there's a real potential issue here where the purchaser could inadvertently deprive the seller of his planning permission by obtaining an incompatible planning permission, and similarly so could the purchaser. So it works both ways. So I suppose commercial property transactions maybe got to be live to this and think about whether you need controls on both sides to manage this sort of eventuality.
Yeah, restrictions on purchasers of phase one's ability to put in new applications that might invalidate the rest, I think is a really good point. So Sophie, even less time for you.
Even less time, right. 2 points very quickly. The first, going right back to the start of the hour, and we were talking about incompatibility between permissions, particularly in relation to conditions and potentially Section 106 agreements. Whilst Pilkington Hillside may not be engaged, there is still potentially a risk of enforcement for a breach of condition where that incompatibility exists. So that's the first thing just to be alive to. The second thing to be alive to, and this is a whole nother session on itself, is where you have statutory instruments like DCOs or Transport and Works Act orders that authorise development, and actually where there's potentially an interplay between a 1990 Act planning permission, for example, a business park built out, and you've then got a DCO that's going to take part of the car park for that. That opens another set of questions. So if you do have a part implemented permission that is impacted by another form of consenting regime, it's something you definitely need advice on.
Really good points to end on. We have broken our golden rule, which we rarely do. We are now a minute over time, so I'm going to end it there. Can I just thank you both very much? Thank you to all the questions that have come through. If we haven't been able to answer them all, please do reach out to us. We'll happily answer those questions offline. Our details are all on LinkedIn and on the DLA Piper website, so don't hesitate to give us a call and ask us the questions we didn't get time for. We will be back on the 8th of December with the planning enforcement session we were planning on doing this month before we all got very excited by Hillside. So I'll be joined by Ian Graves and Joanne Ward, both very experienced in enforcement matters. So we'll have an interesting discussion there on what happens if you get this wrong and they come after you for enforcement for unlawful development. But in the meantime, thank you all very much for listening. Thanks again to you, Michael and Sophie, and goodbye.